and docket.
Thank you, Mr. Shima. I will now call the first case on this morning's docket, State of Kansas versus Jack Mildfelt, case number 1266968. Counsel, you may approach. And Mr. Shire, when you're settled and ready, you may begin your argument.
May it please the court, Sam Shire of the Capital Appeals and Conflicts Office, appearing on behalf of the defendant appellant, Jack Mildfelt. My client, Mr. Mildfelt, was convicted at trial on 6 offenses that were alleged to have been committed against minor victims. The question presented by this appeal is whether those 6 convictions require one $400 Children's Advocacy Center fee or 6 distinct Children's Advocacy Center fees of $400. The Court of Appeals held, as it has in many other cases, that distinct $400 fees are required for each conviction implicating a minor within a case. This court has granted review of that judgment, and that is why we are here today. The starting point for the fee assessment issue before this court is the statute that authorizes that fee assessment. That would be subsection A of KSA 20-370. Removing language that isn't germane to the legal dispute before this court, that statute reads, any defendant convicted of a crime in which a minor is a victim shall pay an assessment fee in the amount of $400. Reliance on the plain and unambiguous text of a statute is the best and only safe way for this court to ascertain the intent of the creators. So if this court can figure out a unit of fee assessment based solely upon the plain language that I just read, that is where this court's analysis should start and end. And it is my view that the plain language of the statute is sufficient for this court to make a determination that the Court of Appeals erred in its unit of fee assessment holding.
Mr. Shire, when I was digging around last week, one interpretation of the statute I was wondering would be $400 per victim. I was looking at the minor child and assessment kind of phrasing. But I didn't see any of the Court of Appeals cases that talked about that variation. You know, there's tons of cases on each charge, a case kind of thing. Are you aware of any? I'm just wondering if you came across any that analyze whether this should be assessed per victim as opposed to the other ways it's been done.
I am not aware of a case. The Court of Appeals probably, in this case, came the closest to that by considering whether the fee assessment was tied to the number of CAC fee assessments implicated by a case. As far as the interpretation that you suggested just now, Your Honor, I don't think that that is permitted by the plain language of the statute, in my view, because the statute starts out by stating who is required to pay a fee. That's any defendant convicted of a crime. Any defendant convicted of a qualifying crime is required to pay an assessment fee of $400. There isn't any statutory language, in my view, that ties that to the number of victims in a case. And I think that might not be, I think that's really, in my view, where this case should start and end. The plain language of the statute permits a fee. A means one. And I appreciate that the Court of Appeals has been very consistent in holding differently. But in my view, those holdings have been, number one, inconsistent, and I don't believe that they should survive legal scrutiny.
Why doesn't a fee, one fee? Why isn't that consistent with the language when you add one fee per crime?
One fee per crime.
You're arguing it should be one fee per case, I guess. Is that right?
Yeah, one fee per case, Your Honor, and more accurately, one fee for a defendant within a case. I think the problem with saying that one fee per a crime in a case is that fees don't pay fines. So there's a $400 fee. Who does the statute say pays that fee? The statute says that a defendant pays that fee. What kind of defendant? A defendant who has been convicted of a qualifying crime.
Wouldn't that create the circumstance where you could have identical defendants treated differently depending on how they're charged?
I don't.
One defendant gets charged in two different cases and gets hit with two fees, and one defendant gets charged for the two crimes in one case and gets only one fee.
Your Honor, I think it could potentially, that may be an argument for another day.
Well, but it may weigh on the meaning of the statute, right? As we consider the implications of the different arguments.
I think it could, Your Honor.
Would that make sense that the legislature would have intended that the sort of random circumstance of how a defendant gets charged would impact the level or the number, I guess I would say, of fees that get assessed?
Well, Your Honor, I think generally speaking, that would certainly be an issue to consider. I could imagine arguing in another case that the fee only needs to be paid once in both of the circumstances that you just outlined, because the statute permits taxation of a fee against a defendant. And it could be argued that once that fee has been taxed, it can't be taxed again.
Ever.
Within this case or in another case.
So once a defendant has paid the fee, they're essentially immune from this. Like, they do their time, they get out, and now recidivism kicks in. 15 years later, they commit another crime, but they can't be charged this fee again.
I think that could be an arguably reasonable interpretation of the statute, Your Honor. It's certainly not the situation we have here. And to the extent that this court is concerned about defendants being treated disparately in different cases, really, defendants are being prejudiced by the interpretation of statute that the Court of Appeals has adopted in this case and so many others. In this case, my client has $24,000 in fees. My client is indigent. He is in prison. He has a life sentence. He is going to remain thousands of dollars in debt for the foreseeable future because of this taxation.
It's $2,400.
Excuse me, Your Honor?
I thought it was 2,400. Not 20.
Did I say a larger number?
I think you said 24,000.
Well, yeah, not that bad, Your Honor. But still, thousands of dollars in debt for the foreseeable future based on the Court of Appeals' interpretation of this fee statute. And I don't think that that's what the legislature intended, and it's certainly not what is demanded by the plain language of the statute.
When you say plain language, it seems to me that you're not just talking about the ordinary meaning of each of these terms, but you're also overlaying grammatical or syntax rules that are common to our language. And in other words, you're suggesting that any defendant is then modified by convicted of a crime under, in which a minor is a victim. So that sort of restrictive modifying clause actually modifies the noun defendant, correct? And that's then how you identify the class of eligible defendants that would pay this assessment fee, right?
That's correct, Your Honor.
Okay. And is that part of a plain language interpretation? I mean, it seems reasonable to me that it would, but oftentimes we just look at, dictionary definitions and not always about sort of, I'm kind of dusting off things I probably should have learned better in high school English class, but to understand the plain language argument here.
Well, Your Honor, I think that there is some syntax involved in this interpretation of statute. What I think this boils down to is that it doesn't read naturally or make sense for the number of crimes to determine the amount of the fee, because a crime doesn't pay a fee. So we know that the phrase
Right. Crime modifies defendant, not an assessment fee.
Not an assessment fee, because a crime can't pay a fee. It wouldn't make sense to read the statute that way. And I would, excuse me,
No, please continue.
I would also just note that if this court finds that syntax or plain language leads to some ambiguity in terms of what the legislature intended with the enactment of this law, that ambiguity needs to be resolved in favor of criminal defendants. And I think that's really the final nail in the coffin as far as the Court of Appeals' interpretation of this fee statute. Because criminal defendants would clearly categorically benefit from an interpretation of statute that limited a district court to assessing a singular $400 fee.
Wouldn't we need to also look into legislative history?
I don't think that this court would need to do that.
Why not?
Well, because the rule of lenity is based on the plain language of the statute. And what it says basically is that any ambiguity in that plain language needs to be resolved in favor of criminal defendants, with the exception that an interpretation of statute can't be unreasonable.
I think in our recent case law, we have described the rule of lenity not as a conversation ender, but merely as one of several tools or rules of statutory construction to be applied that needs to be considered in the totality. In other words, we don't just say rule of lenity, case over. We say rule of lenity is an important tool of statutory construction, but it gets put in bucket, as it were, with other tools like legislative history.
Well, Your Honor, I think even if you do get past the rule of lenity case and look at the legislative history that's cited by the McDuffie opinion, which is sort of the genesis of this issue, that legislative history really doesn't support the court's conclusion in the way the court thought it did, in my view. The court cites the legislative history for the proposition that the legislature wanted criminal defendants to be financially responsible. Well,
right, and wouldn't it make sense that that legislative history at least has an inference that the legislature thought you ought to pay this fee every time you commit a crime against a child?
Your Honor, I don't think so. Number one, going back to the plain language, I don't think that's what was done with the plain language. I think making the fee assessment a unit of one still holds criminal defendants financially responsible. It's certainly not the case that I am asking this court for a waiver of financial liability, totally. I'm just asking this court to permit the district court to tax a single fee. I didn't see anything in the McDuffie opinion that supported a finding that the legislature clearly and unambiguously wanted the assessment of multiple fees. And that takes us back to the rule of lenity, and the rule of lenity clearly weighs in our favor in this case. Unless this court has any further questions, I will reserve the remainder of my time for rebuttal.
Good morning. May it please the court. Tyler Winslow, Assistant Solicitor General, appearing on behalf of the state of Kansas. It's either clear and the KSA 2370 sub A requires one CAC fee per crime of conviction, or it is ambiguous and it's still ultimately the legislative intent, the results of the statute as it's interpreted, clearly require a 1-to-1 crime to fee ratio.
Can you pivot to what counsel just finished with, which was a statement that said there's nothing in the legislative history that plainly shows, what the legislature intended, and I just want to know where you think that plain language is in the.
I'm actually, I turned back to McDuffie. So at page 17 of the Westlaw opinion is where they delved into the legislative history. I think it's the testimony of one of the state senators. I'm sorry, it's at page 20, discussing the testimony of Senator, or not the testimony, the discussion of Senator Smith in a letter supporting the amendment to the House Appropriations Committee. So one of the McDuffie purposes of the statute was revenue generation for child advocacy centers. And so one of when the bill was being discussed back in 2014 or 2004, and then again in 2013, when it's being rediscussed, is to bring revenue for child advocacy centers to actually conduct these interviews. And so that is in the legislative history where I'd point this court back to.
And why would a letter from one legislator out of 165 tip the balance of this discussion about legislative history?
Because as this court's looking into legislative history, that's part of the process. And to
That was just one. I'm just saying it's just one letter from I mean, you can line up 165 legislators and get 165 different interpretations of what was intended by this language. And I'm just trying to figure out, why should Senator Smith carry any greater weight than anything else?
Because that's what paints the conversation. So if there are 106 senators and one presents a letter and no one responds, that is part of the piece of the puzzle for this court to consider.
It's a piece of the puzzle, but I'm trying to figure out how much weight to give it.
Yes, Your Honor. And that, so why else would the legislature contemplate a $400 fee if not to generate revenue? So taking the comment from a senator, even one, that is in context of to the House Appropriations Committee to consider how this could be used and how this could benefit the state overall.
Isn't there another comment, though, in the history that this provision isn't going to raise a bunch of revenue?
I think, I mean, to some extent, that's a pragmatic response as well to the functional posture similar to this case. If I recall the actual sentencing structure in this case, it's 4 consecutive hard 25 sentences. So the result being, from a practical perspective, it's not entirely clear to what extent, but the ultimate result in interpreting the statute is still, it is at least in part meant to generate funding.
Can you give me some idea of how the Child Advocacy Center operates for these victims of, horrendous crimes? I'm just curious. So if there is a single victim that has incurred maybe multiple instances, and there may be multiple convictions for a single defendant and a single victim, does that change the process or the treatment that they undergo through the advocacy center?
Not from my understanding, particularly, and I'm trying to tie this back to the record in this case, but generally I'd say kind of functionally the way this case happened is you have one victim go to a CAC, disclose, and then the investigation kind of ensues from there. And then you identify more victims that potentially also go to the CAC. In other cases, again, not in this record specifically that I can think of, I've seen entire families go to CACs for interviews, even just from one disclosure or one CPS report to just make sure the kids are all safe. Ultimately, and I'd say,
I guess because I'm tying it back to the statute, if you have, for example, a single defendant convicted of multiple offenses versus a single victim, does that change versus a case where there may be 2 convictions with 2 victims?
No, Your Honor, and that is actually this case. There are 2 charged victims in this case, 6 convictions. So as far as this case really, I think presents and from the initial step of the analysis, is the statute ambiguous? That's why the state briefed McDuffie below and not Sanders or another case, is that there do appear to be at least 3 reasonable interpretations. In terms of that first step of the analysis is fee to crime, victim to crime. And really, I think the Court of Appeals in this particular case tipped their hat to that reality by saying the fee per assessment analysis is potentially another way, a reasonable way of reading the statute. So the problem, I'd say, with the per assessment analysis is actually it would be per assessment that results in a conviction, because I don't know that the state could impose a fee for a crime without securing the conviction first, without more clarity from the statute for how that would actually work.
I think there's a lot of appeal from a public policy perspective for that to be the case. I'm just curious how you would get there, because I think even the panel below ends up with a plain language interpretation and not following the McDuffie approach. But how would you suggest that could be supported under either rules of statutory construction or legislative history or any other canon?
To get there under the plain language, that has to fall under the meaning of the word crime in the statute. So if by crime, if crime is synonymous with crime of conviction, that would preclude that analysis. If crime is more general and generally refers to a wrongdoing that is a violation of Kansas statute, that does not necessarily require the conviction, then the assessment on its own would be sufficient. Or another potential interpretation of that would even be if there is one crime, I guess this is how you would actually get there. If there's one crime of conviction, similarly to investigation related fees, like the KBI fee, for example, if just the fact that we had to have all these assessments can be tied back to the crime of conviction that initiated that investigation. But again, I think just the fact that there are 3 potential ways of delving into the meaning of the word crime in this particular statute indicates that it is ambiguous, and that this court should turn to the legislative history, the rule of lenity, kind of the bucket of tools that Justice Stegall referenced, absurd results that ultimately reveal a per crime assessment is what 2370A is meant to encompass. Any further questions from the court?
This might not be fair, and I'm even hesitant to bring it up. We had a case maybe 10 years ago involving drug tax stamps. And the question before the court was whether or not, if you possess multiple types of drugs, and it supports whether you can assess whether you can charge one drug tax stamp violation first on the case, or based upon the multiple possession of drugs that's being charged. It's not analogous exactly, because we're talking charging of crimes versus a fee. I appreciate that. But is there any similarity? We ultimately held, it was a divided decision, but we ultimately held that no, it only supports one charge of a drug tax stamp. And I'm wondering, is there any, is that analogous at all? And I know it's probably specific to that particular statute, but as I'm listening to the argument, I remember we all struggled with that question.
No, I don't think they are similar in this case, because
when the consideration is whether multiple charges can originate from possession of multiple substances when it's all together. That to me, not having specifically read that opinion, turns to kind of a multiplicity analysis. Can we charge, is this multiple criminal acts or a single criminal act? In this case, there are multiple, we have distinct criminal convictions. And so that's really, I'd say to best summarize the state's position is the fee assessment is per crime of conviction. Just as it was in this case. We had 2 victims, 6 counts, 6 convictions, 6 CAC fees.
But were there 6, were there actually 6 fees incurred, or were there really only 2 because it's tied to the number of victims?
The state's position is that it ties back to the convictions. But
Well, I understand that argument.
If this court goes with a per assessment or per charged victim analysis, then there would be 2, if I'm remembering the charge sheets. Correct.
That's the one option that I just frankly don't understand. I get it from a policy perspective. Like it might have been good policy for the legislature to say per victim, but I don't see how you get there from this statute, even if it's ambiguous. I mean, can you point to anything in the statute that suggests it's a per victim calculation?
No, Your Honor. And I think to craft that analysis, this court would have to rewrite the statute to include a per.
Aren't the options in front of us really as simple as either it's per crime or any single defendant out there only ever has to pay this fee once? Aren't those the only kind of 2 possibilities under the language of the statute? And
Under the plain, just if this court is going to.
Well, whether it's plain language or ambiguous, it's just like I'm trying to narrow the universe of potential outcomes. And it seems to me those are the only 2 potential outcomes.
I'd agree with you, but I would also add the statute doesn't say a defendant. It doesn't contemplate one defendant. It contemplates any defendant, which would include a defendant who's previously been convicted and charged to CAC.
I understand you have plenty of arguments for why this ought to be read to be tied to conviction, because conviction happens to be the word that's used in the statute. But I'm just suggesting that if you're wrong about that, I don't see any other options than what opposing counsel suggested, which is any single defendant only ever has to pay this fee one time, no matter what.
I would say that runs into, because as that was discussed, that was the way it was phrased was a defendant. And so that's where I guess that's my
I understand that you don't think that's an appropriate.
But I'm sorry. I think you're right. I think the only 2 options are per case. Well, I guess I was thinking the option was per
okay,
case.
so why is per case a valid option? Again, it strikes me that there's just nothing. I understand why as a policy matter, it would make a lot of sense to say per case. But just how in the world would you get there from this language?
Because it would have to be inherent in the conviction. So because the statute references a conviction, the only way to get there, and I see I'm running out of time, the only way to get there would be through a case. But again, that's
okay.
More steps to the analysis. Any further questions from the court?
Further questions, Colin? Thank you.
I'll ask the court to affirm.
Thank you, Mr. Winslow. Mr. Shire, you reserve 3 minutes.
May it please the court? I just wanted to highlight, in my view, the dangers of trying to read tea leaves in legislative history. And one of the biggest problems with trying to interpret statute based on legislative history is that the legislature is not a single-brained entity. What one legislature may have said in testimony doesn't necessarily reflect what the 150 plus other legislatures may have been thinking when they chose to enact a statute. And for that reason, I think it's very dangerous to rely solely upon what Senator Smith said, and I believe a summary, not even a transcribed accounting of his testimony, is my understanding, based on what was stated by the Court of Appeals. The other thing I would note on that front is that the Senator Smith testimony that the Court of Appeals cited was from 2013, and it was in support of a statutory amendment that made a CAC fee unwaivable and increased the fee from $100 to $400. That statutory amendment had no bearing whatsoever on the unit of fee assessment that the legislature created in 2004. And so for that reason alone, I don't think it can be relied upon by this court when it's interpreting the statute at hand today.
If the court finds the statute's ambiguous, just from a reasonability perspective, why would this be a one-time in perpetuity assessment as opposed to per conviction? Is there an argument just in terms of just the reasonability if we're in ambiguity territory?
Well, Your Honor, one thing I want to make clear is what we're advocating today is one fee per case. I know we got off on a tangent and argument about one fee in perpetuity, and I suggested that that could be a possibility. And I do think that's something that could be argued in a future case. But I am not taking a firm position today with the case I have before this court that it's one fee in perpetuity. I believe that it is at most one fee per case, and I believe that's eminently reasonable. Unless this court has any further questions, I will conclude my argument at this time.
Any other questions, colleague? Thank you, Mr. Shire. Thank you both for your arguments this morning. This matter will be taken under advisement.